Good afternoon, everyone, and welcome to another webinar in the AlphaStaff webinar series. Thank you for joining us. I hope you will take a lot of notes today because this is a very important topic, especially if you have 15 or more employees. And I'm going to rely on our speaker to correct me if I'm wrong there. Both the Americans with Disabilities Act and the Family Medical Leave Act does have certain criteria. Now I'd like to introduce our presenter, Donald C. Works III. He is a principal with Jackson Lewis in their Orlando office. He specializes in all aspects of employment law, representing management, which is great. He has his Bachelor's of Science degree in Personnel Management and Industrial Relations from Auburn University and his Juris Doctorate from the University of Miami. He serves as the State Director of Government Affairs for HR Florida and has been the past president of the Central Florida HR Association as well as the HR Association of Broward County. He does maintain his certifications with SHRM. This is a Society for Human Resource Management as a senior certified professional and also a senior professional in HR with HRCI. He frequently presents and has published several articles on wage and hour as well as employment law topics. And he's been recognized by his peers in the publications Best Lawyers in America and Florida's Super Lawyers. So you are in very good hands today. Please don't be shy with those questions. And now, Don, I'll turn the webinar over to you.
Well, thank you very much, Sandy, and good afternoon, everyone. This afternoon, we're going to be trying to bring you up to date with the latest developments with regard to the Americans with Disabilities Act and also the Family and Medical Leave Act. As Sandy indicated, the Americans with Disabilities Act applies to employers of 15 or more employees, and the Family and Medical Leave Act applies to employers with 50 or more employees. That's 50. So both of these laws affect employers who have employees with a serious health condition, which typically would constitute a disability under the ADA as well. So if you're a smaller employer and you're only covered by the ADA and not the FMLA, what we'll talk about with regard to the FMLA in many cases has applicability to your case under the ADA. A good bit of my time is spent litigating cases under these laws, but I'd say 30 to 45% of our firm's practice is counseling. And on a day-to-day basis, the questions that we get from employers are wide-ranging, as you might imagine. I mean, we deal with workplace safety issues, immigration issues, a number of different wage and hour issues, but by far the most frequently asked questions by employers that we get on a day-to-day basis involve the Americans with Disabilities Act and the Family and Medical Leave Act and how they interact. So today what I'd like to do is spend some time talking about key issues that we find that employers are encountering under these laws. And we're going to look at some related case law. These are decisions from the courts that are starting to provide us some guidance with regard to notice that's required under the FMLA, the interactive process under the ADA, medical examinations, can you require them? What about FMLA and bonuses that would have been earned while somebody was out, or substitution of paid leave? These are the different topics that we hear from employers on a daily basis. And over the last several years, we've had some courts come down with decisions that provide a lot of guidance and are very helpful to us. So we'll spend about an hour this afternoon looking at those decisions, and I think that you'll find them very helpful to you in making decisions in your workplace. So let's start with the Family and Medical Leave Act and employee notice issue. This is an issue that comes up regularly, and it is how often or how does an employee go about giving you notice when they want to take leave under the Family and Medical Leave Act? Well, typically an employee will come forward at some point and let you know that either they have a serious health condition or a family member does, and that they're going to be needing to take FMLA leave. As many of you probably know, leave can be taken on a continuous basis or it can be taken intermittently. And this leads to a lot of problems for employers, in particular with the intermittent leave, because an employee may not show up one day and then later tell you that, oh, that day should be counted as FMLA leave because I had a migraine headache that day, or whatever the reason was for their FMLA leave. That notice after the fact makes it very difficult for you as an employer to schedule, to make sure work is covered on any given day, and to account for the whereabouts of your employees. So one of the things that we have learned recently from case law is that under the law, you still have the right to require the employee who is taking FMLA leave to comply with your usual notice requirements for requesting leave, unless there are unusual circumstances. So if you, in your handbook or your company procedures, say that when somebody's going to be absent, regardless of whether they're on the FMLA or not, if they're going to be absent, they need to contact a particular individual, for example, their supervisor or HR, or call a particular number, or contact a third-party leave administrator if it's an FMLA case. If you have those policies in place, then you can require somebody who's out on FMLA to follow those policies. A good example of a case dealing with this issue is in the next slide. It's the case of Acker versus GM LLC. In the Acker case, as you can see in the next slide, this is a decision from the Fifth Circuit Court of Appeals from 2017. Acker was approved for intermittent FMLA leave. The company was requiring employees, that is all employees who took intermittent leave, to call their absence line at least 30 minutes prior to the shift that they were going to miss, and also to call the third-party leave administrator by the end of their scheduled work shift to report that they were going to be taking the time off or took the time off as intermittent FMLA leave. Now, Ms. Acker was disciplined, or Mr. Acker was disciplined when on several occasions he failed to follow those procedures. And ultimately, he was terminated for failing to follow those procedures. And the court ruled that an employer does not violate the law by terminating an employee for failing to comply with its policy, provided you are enforcing that policy uniformly with both people who are on FMLA and those who are not on FMLA. So if you have folks who are out on FMLA leave and they're not following your call-in procedures, you can write them up for failing to follow those procedures. And ultimately, if it gets severe, consider termination. Now, that's not without limitation. As you can see in the next slide, the case of Bodie versus Center for Human Resource or Human Development, a case out of Massachusetts from 2017. Now, Bodie was hospitalized for having a psychotic disorder and was unable to act in her own best interest. So her son called the employer and reported the absence. The employer told the son, you need to have your mother call in because our rules and our procedures require that the employee themselves report the absence. She did not do so and was ultimately terminated for no call, no show. The court held that in this type of unusual circumstance where there's an emergency, or in this case, she had a psychotic disorder, she couldn't act for herself. In those circumstances, a failure to comply with an employer's call-out policies cannot be held against the employee and used to discipline the employee. Doing so would be a violation of the Family and Medical Leave Act. So you can see from these two cases, unless there are unusual circumstances like in the Bodie case, you as an employer have pretty good latitude here in terms of strictly enforcing your call-in procedures with people who are out on FMLA. This should help a lot of you who have employees who are not real diligent about calling in, and who call in after the fact or the next day tell you that, oh, the reason I was out yesterday was because of my FMLA, when you know full well that they were at the beach or the park or whatever else they might have been doing. So this gives you some latitude in starting to enforce your call-in procedures under the law. So that's one development in the FMLA area. Let's switch gears and look at the ADA for a moment. Now, under the Americans with Disabilities Act, if you have an employee who has a disability, they may need an accommodation. And the law would require that you provide accommodations for employees who have disabilities, as long as it doesn't create an undue hardship for you, the employer. Now, I've used a lot of key words in the last couple sentences, employee with a, quote, disability, quote, reasonable accommodation, quote, undue hardship. All of those are key terms of art under the Americans with Disabilities Act. But in considering this issue, I urge you to put that legal technicality stuff aside, just put it aside. This should be approached, in my opinion, like the law never existed, like you were a small business who was just trying to take care of your employees. If you do that, you'll be golden under the ADA, because what the ADA interactive process really requires is that you sit down with the employee and talk to them, gather information about the nature of their disability, about what they can and cannot do. Try to explore ways with them as to how you can enable them to do the job. And years ago, before the ADA ever existed and we started worrying about all the legal technicalities, that's what employers usually did. They tried to work with employees to find a solution, particularly if it was a good employee. So the ADA is simply codifying what you should have already been doing, which is to try to work with your employees and be flexible to find a way to enable them to perform the functions of the job. Now, this is a two-way street under the ADA. Both you, the employer, and the employee have an obligation to engage in this interactive process in good faith. And you've got to be flexible doing that. You want to try to obtain information from both the supervisor and also the employee, and potentially the individual's healthcare provider as well. So let's look at a couple cases that we've got from courts dealing with this interactive process. The first one that I'd like to call to your attention is this Keith versus County of Oakland. It's a decision out of the Sixth Circuit Court of Appeals from 2013. Now, in this case, Mr. Keith sued the county after he was not hired as a lifeguard because he was deaf. He was initially offered the position, but told that he had to pass a medical examination. The physician refused to clear him, simply saying he's deaf, he can't be a lifeguard. On appeal, the court held that there was a question of fact as to whether or not he was otherwise qualified under the ADA. What the court is saying there, and using legalese, is that the jury needs to find out whether or not they just closed the door assuming he couldn't do the job, or whether there was some interaction between the employer and the prospective employee trying to find a way to enable him to do the job of a lifeguard. And that issue of fact precluded summary judgment, and they remanded the case for a jury trial on the issue. So what you see here is an example of how you can't jump to conclusions about somebody based upon their disability. You have to engage in that interactive process and see whether or not there's some way that they could do the job, even though you might presume they could not. So that's the Keith versus County of Oakland decision. Another case dealing with the issue of failure to engage in the interactive process is the Alexander versus Montana Developmental Center, a case out of Montana from 2018. In this case, Alexander, whose job required him to be able to physically restrain mentally disabled clients, was injured and he could no longer do that. the employer tried to explore what types of other positions he might be able to fill with them for a short period of time until he got better and he could go back and perform his normal job. And they asked him to provide his qualifications, education, training, so that they could see whether there was another vacant position that he could fill. Well, Mr. Alexander refused or failed to give them the information they had requested. And so the employer said, okay, well, we can't work with you. We've got no alternative but to terminate you. There's no place you can't do your existing job. You won't work with us to find another vacant position that you're qualified for, so we're going to terminate your employment. He sued under the ADA, claiming failure to engage in the interactive process, failure to accommodate him, and the court ruled in favor of the employer. And the reason they ruled in favor of the employer is because Mr. Alexander failed to engage in the interactive process. So you see, it's a two-way street. Not only the employer has to do this, but the employee has to engage in that process as well. All right, we'll shift gears and go back to the FMLA. Another issue that presents itself rather regularly under the ADA are cases where you learn that somebody's actually out working during FMLA, or you need them to do some work on an intermittent basis while they're out on FMLA. So in the first case, the Dion Frio case, a Fifth Circuit decision from 2018, the employee was a sales representative and she requested leave to take care of her husband. Now, when she requested leave, the employer gave her two options. She could just go out straight on unpaid FMLA, or she could work a few times a week to continue servicing her existing accounts so she could keep her commissions while she was on leave. She chose the latter option. Sounds good. You get to have FMLA, work a little, keep your commissions. But while she was on leave, the employer learned that her husband was setting up a competing business. So in that case, they terminated her access to the systems. They didn't want her having access to their systems and being able to take advantage of that to help her husband set up this competing business. You can see in the next slide the ultimate outcome of the case. In this case, when the employer learned that she was not servicing her accounts, they terminated her systems access, as I indicated. And then at the end of the leave, she claimed that she had been terminated. Not just that her systems access had been denied, but that she had been terminated from her work, claimed that she was constructively discharged, and then sued her employer, claiming that they had interfered with her FMLA rights by asking her if she wished to continue working during her leave at the outset of the leave. And the court held that when an employer gives the employee the option at the outset of the leave to either take unpaid leave or work some while they were out on leave, and the employee selects the latter option, that's not unlawful interference with their right to take leave. So there is some middle ground here with your employees. If you want to try to find a way that they can work and only take leave intermittently, you can explore that option without it being deemed to be interference with their right to take leave, particularly where you give them the option and they voluntarily select that latter option to work during the leave. All right, another instructive case on FMLA. Now I want to turn our attention back to the ADA for a moment and talk about medical exams. I think a lot of employers are scared off by the ADA from doing medical exams. When the law was originally passed, there was much talk about how employers could simply no longer do them. It was just so difficult to comply with the law that you might as well forget about medical exams. That's actually not the case. With current employees, during their employment, you can conduct exams if they are job-related and consistent with business necessity. So anytime an employee requests an accommodation, you could ask for them to have a medical exam. Anytime their ability to perform the job is impaired, you can ask that they have an exam. If they pose a safety threat to others or themselves, you can ask that they have an exam. And you can also ask for an exam if it's required by OSHA, the DOT, or sometimes state laws. That's permissible as well. So you have a good bit of latitude during employment to do medical exams. I guess that next question then is, what is a medical exam? And you can see in the next slide, it's basically any procedure or test that seeks information about the individual's physical or mental impairments or health. So it's very broad what would be considered a medical exam. That being said, you can conduct exams in many, many cases. Generalized concerns about employee safety are not enough. You have to have some demonstrable evidence that their safety is at risk in order to pursue that line or that authority and conduct a medical exam. So we've talked about medical exams with current employees. Let's talk about medical exams with applicants. With applicants, you even have more flexibility because post-offer, pre-employment, it's okay to do a medical exam if you require it of everybody who is applying for a job in the same job category. The exam does not have to be job-related unless ultimately you're going to use the results for some purpose, in which case you'd have to show that it was job-related. So there is a little bit more latitude here, but you have to remember that you, if you go down this road, would have to pay for the testing. A good example of that requirement that you pay for the testing is found in the next case, and that is EEOC versus BNSF. In the BNSF case, the company conditioned an offer of employment upon a medical review. During the medical review, the candidate disclosed an old back injury. And so the company requested that he have an MRI at his own expense. The court held that an employer cannot do that, that you would have the obligation to pay for the post-offer pre-employment medical exam. In that particular case, the MRI was going to cost the individual almost $2,000. So the court focused on that. Note that this is the Ninth Circuit Court of Appeals on the West Coast of the United States, which is known for being very employee friendly. And they said that $2,000 is simply too much. If you're going to require a medical exam pre-employment, then you, the employer, must pay for it. All right, moving on. Let's take a look at the FMLA and what might be known as the escalator principle under the FMLA. It's referred to that under other laws. But basically, under the FMLA, you know that when the employee is able to return to work, you have to restore them to the same or substantially equivalent position that they held before with the same pay and benefits. So the question arises, what about pay increases that might have occurred during the leave? For example, if you gave everybody a 3% cost of living increase on July 1st and the person was out on leave on July 1st, would you have to give them that leave as that pay increase as well, even though they were out on leave? And the answer to that question is yes. It's something that would have happened irrespective of the leave. Another example is pay increases that would have been triggered by seniority or particular work performed have to be granted as long as you are granting it to persons who are on non-FMLA leaves. So if other people are out for absences that are not FMLA related and you give them pay increases based upon these criteria, then you have to give it to persons who have taken an FMLA leave as well. Now, they are entitled to be restored to the same position with the same or equivalent pay premiums. For example, if they were getting a shift differential before, you can't put them on another shift and take that away. Again, it's the same or substantially equivalent position there's to be restored to. Finally, is the question of what about a bonus or other payment that was based upon achievement of a goal, for example, sales. Do they get the commissions? Do they get bonuses? Well, if somebody's out on leave, very often it's difficult for them to make the sale and qualify for the bonus. So the question is, can you hold the fact that they were out on leave against them? Can you hold the fact that they didn't meet their goal because they were out on leave against them when it comes to bonuses? And the answer is yes, you can. Even though somebody is missing goal and not getting a bonus because of the FMLA leave, you do not have to pay them that bonus. Caveat, if you pay it to persons who don't achieve their goal as a result of non-FMLA leave, then you would have to pay it to somebody who's on FMLA as well. I trust that makes sense. Look at the next case, the Flowers case versus McCartney in the next slide. In this case, Ms. Flowers was a nurse and she got a 30% shift differential if she did not miss more than 6 weekend shifts. She ends up missing more than 6 weekend shifts due to her FMLA leave. And when she comes back, they discontinued her shift differential. Now, ordinarily, if somebody were automatically qualified for a shift differential, they would have to get it upon their return. But where the shift differential is qualified or conditioned upon the employee satisfying a requirement, like not missing more than 6 weekend shifts, and they do not satisfy that requirement or meet that condition, then you can deny the shift differential in that case. And that's exactly what the employer did in the Flowers case. And the court held that the FMLA allowed the employer to withhold the bonus that was based on achievement of a goal related to hours or attendance. This is a very recent case, and it clarifies an area that's been of concern to a lot of employers who employ salespeople in particular, who were not able to qualify for bonuses or commissions because simply were not there enough to make enough sales. This gives you some latitude. Okay, another issue under the FMLA, we've dealt with bonuses there and notice required. Let's talk about whether you can require an employee to use up their PTO or other paid leave during an FMLA leave of absence. If you have general PTO, typically if it's an unpaid FMLA leave, you can require that the employee use that PTO. If, on the other hand, you have vacation and sick time separate from one another, you can only require that they exhaust their sick time if the leave is being taken for a serious health condition. You could require that they exhaust vacation during other types of FMLA leave. Now, what if the person's receiving some or other sort of compensation or some other benefit while they're out on FMLA? Could you still require that they exhaust PTO or exhaust vacation time? Well, that's the issue that arose in the next case, the REPA versus Roadway Express case. In that case, the employee was out on FMLA leave for 6 weeks. And during their leave, they got a disability payment. So they had maybe like a short-term disability insurance or AFLAC or one of these other benefits during a short-term disability. And the employer required her to use her paid vacation and sick time during that period. She sued seeking to have her sick leave and her benefits restored. And the court said that where the employee is receiving compensation or pay during the FMLA leave, you cannot require that they substitute paid leave for the unpaid time they're out on FMLA. So the employee has the option. If they want to, they could, but you cannot require that they exhaust paid leave if they're receiving any sort of benefit during that period of FMLA leave. In the next slide, you can see that it really is not a question of how much the person received. For example, in the REPA case, she only got $300 a week. and that wasn't enough to cover what her pay would have otherwise been. In those cases, no matter how much the income replacement is, you still cannot require them to use their PTO. So it looks like there's a question here, and I can't read the entire question. It looks like somebody is asking, not understanding FMLA and substitution. Can we mandate that they use vacation and sick time? Okay, the answer to that is you can mandate that they use vacation and sick time during an FMLA leave if the leave is for a serious health condition. If it is not for a serious health condition, you cannot mandate that they use the accrued sick time. With that in mind, if they receive any other sort of benefit, such as this disability benefit that REPA received, then you cannot require that they use either the vacation or the sick time. I hope that answers the question and clarifies things. All right, so, and we can come back to that after we wrap today if you've got additional questions. All right, so let's talk about the ADA, FMLA, and how they kind of interact. Like, what do you do when FMLA is exhausted? If you look at the 2 slides ahead, we're going to talk about inflexible leave policies. The key here is not to administer FMLA in a vacuum. Once FMLA is exhausted, if the leave was for a serious health condition, it might also qualify as a disability. So at that point, once FMLA is exhausted, you have to engage in that interactive process and determine whether an accommodation could be made for the individual under the ADA. In the next slide, you can see that the EEOC and also the courts have struck down policies that have automatic termination when FMLA is exhausted, or require people to return to work with no restrictions. Under the law, you have to engage in that interactive process and do an individualized assessment to see if the person can perform the job with or without a reasonable accommodation at the conclusion of the FMLA leave. All right, so let's look at the next issue that presents itself. So FMLA is exhausted. You talk to the employee and you say, okay, your 12 weeks is up. Are you coming back to work? And the employee says, well, I'm not quite ready. My doctor says that it's probably going to be a few more weeks or maybe a few more months before I'm ready. So you, the employer, are in a position of having to decide, okay, can we allow a few more weeks or a few more months as an accommodation to this person under the ADA? And what we're finding is that courts are starting to rule that a, quote, few weeks or, quote, few months is too indefinite, and you don't have to allow that as a reasonable accommodation. In the next slide, you can see a case on point. Easter versus Arkansas Children's Hospital, a case out of Arkansas from last year. In that case, a nurse took FMLA leave for issues with her esophagus. After her leave was expired, she was given another week of leave. After another week, the doctor stated that she was, quote, unable to perform her current line of work for an indefinite amount of time. At that point, the hospital denied her request for additional leave and terminated her employment. In that case, the court ruled in favor of the hospital because indefinite leave is not a reasonable accommodation. One cautionary note here, they probably should have explored with her whether or not there might be some other job she could do, or there was a way that she could do her job and come back on maybe a part-time or intermittent basis, rather than just shutting it down, indefinite leave, you're out of here. That interactive process would put them in an even stronger position. But you still see the bottom line message here in this case, which is a request for indefinite leave is not a reasonable accommodation. So if you get those types of requests at the end of FMLA, you are not obligated to extend leave on an ongoing basis for a person who has a disability. Two different cases are shown in the next slide. The Huang versus Kansas State University case, where a 6-month leave of absence was not deemed to be a reasonable accommodation. And also the Severson case, which is one that employers rely upon quite frequently, a case out of the 7th Circuit Court of Appeals from 2017, where an employee who needed long-term medical leave, multi-month leave of absence, was not entitled to that as a reasonable accommodation. All right, that being said, let's take a look at one other case, the EEOC versus S&C Electric Company, a case that came out of Illinois last year. Now, in that case, the employee had been out on FMLA and then was on long-term disability for 12 months. At the end of that period, the employee wanted to come back to work. In that case, the company, relying on that Severson decision that I mentioned a moment ago, argued that the person had been on a long-term indefinite leave and therefore they weren't protected by the ADA. They ignored the fact, however, that unlike the employee in Severson, this employee had been released and was ready to return to work. So this wasn't a case where they were trying to decide whether additional leave was a reasonable accommodation and Severson was inapplicable. So if you've already allowed the extended leave and the person then wants to come back, it's likely you'll have to consider them for employment under the ADA. Now, just, I guess, with regard to leave as a reasonable accommodation, there's certain things to keep in mind. As you can see in the next slide, that Severson, and as you can see as illustrated by the EEOC versus S&C case I just mentioned, you can see that Severson is not a per se rule. In each case, you've got to look at whether or not presence at the job site is an essential function of the job. Would the absences be excessive in relation to the job duties? I mean, some jobs accommodate leave better than others. What was the employer's motive in denying leave? I mean, why were they claiming an undue hardship, or did they just not work with the employee? What's been done with others? How have you handled non-disabled employees? Were they given more generous leave, say somebody who wanted to take a sabbatical to go back to school for a year or two? And then finally, you should look at whether or not any other accommodations would be available. So the moral of the story here with indefinite leave is, generally speaking, you do not have to allow an indefinite leave as a reasonable accommodation under the ADA. It is not reasonable if it's indefinite. However, that is not a per se rule. Every case is different. You've got to look at the particular employee, what their job is, what their job duties are, what you've done for others, in determining whether additional leave might be a reasonable accommodation. Okay, moving along, another issue that frequently raises its head in this arena is the issue of FMLA abuse. And in my occupation, as you might imagine, I've heard it all. I have heard the employee who has migraine headaches coincidentally every Friday and every Monday, or the employee who says they're out taking leave to donate a kidney for an individual, but it turns out they're out running their own business during the FMLA leave and have had no medical treatment whatsoever. So there are employees who will take advantage and abuse the system. I guess that's just the way it is, and it has been for years. There is a developing line of cases under the FMLA that gives you, the employer, a defense if you terminate somebody for misusing FMLA leave. In the line of cases and the defense, it's basically called the honest belief defense. If you have an honest belief, not absolute certainty, but the honest belief that somebody has misused FMLA, and you in good faith take action against them after you look into it further, give them an opportunity to explain, then you will have a defense to a claim of retaliation under the FMLA. Now, different circuits apply the defense differently, so if you get into one of these situations, be sure to consult with counsel to find out what might happen in your jurisdiction. But generally speaking, if you gain information that indicates that an employee is abusing FMLA and you investigate it and you confirm that in fact they are abusing it, then you can take action against them and terminate them. A case on point is the Samuel versus PHI Air Medical case. You can see in the next slide a case out of the Eastern District of Kentucky from 2018, last year. It's a flight paramedic who had a side business, and they knew about the side business, but he was not supposed to be doing that while he was out on leave. He was out on bonding leave to care for his newborn child. But while he was out, he was attending events for his side business. And when he was questioned about it, he denied doing that. Well, they had proof that, in fact, he had been doing that. So they terminated his employment, and the court ruled in favor of the employer based upon their good faith, honest belief that he was using FMLA for fraudulent purposes. Now, one of the ways PHI or other employers become aware of this fraudulent use of FMLA or abuse of FMLA is through social media. And social media has been used quite frequently by employers to check up on employees who are out on FMLA. So jumping 2 slides ahead, this is the last case we'll look at this afternoon, but it's an interesting one. The Lineberry versus Detroit Medical Center case, a case out of the Eastern District of Michigan from 2013. This case involved an RN who was on an approved FMLA leave because she had back and leg injuries, or she purported to have back and leg injuries. The medical center, looking at her social media, learned that she took a planned trip to Mexico while she was out on leave. And when they asked her about that, she said, oh yeah, well, I needed a wheelchair to get through the airport. And then other employees started to see posts on Facebook that were contrary to her assertion that she had back and leg injuries, and they reported that to management. Eventually, the employer terminates Ms. Lineberry, and she sues, alleging FMLA interference and retaliation. Looking at the next 2 slides, you'll understand why the court ultimately ruled in favor of the employer. In this slide, you can see here's Ms. Lineberry, and she's standing up, appears to be quite able to stand, notwithstanding her alleged back and leg injuries, is holding her 2 grandbabies. And this is during the time she's supposedly not able to get out and about because she's on FMLA. And then they found another telling sign on social media. You can see in the next slide, and you'll note these are marked in the lower right-hand corner as deposition exhibits because they were introduced in a deposition in her case against the company. And in the second slide that they found online, it says, Dos cervezas, por favor. You can see down at the bottom as she's holding 2 beers and lying on the bed on her vacation in Mexico. So based upon this type of evidence, the court ruled that she was well within her rights, that the employer was well within its rights to terminate her employer. So you can see from the cases we've covered this afternoon, there have been a lot of developments on the ADA and FMLA front. For the most part, they're very employer friendly. They give you a good bit of latitude in how you handle situations where employees are out on FMLA or where they have a need for an accommodation under the ADA. As long as you're working with the employee, which I encourage you to do consulting with your HR professionals at AlphaStaff, as long as you're working with the employee and genuinely making an effort to make it work, then you'll be in good shape under the laws. The last thing I want to mention are some trends that we see. For one thing, we're starting to see state and local laws being amended to provide paid leave on a local basis. There are many state and local laws requiring paid family leave now, paid sick leave. Some are requiring parental leave for parents to attend school events. Another development we're seeing with employers is the adoption of unlimited PTO policies. This is really quite interesting. We're seeing more and more employers do this. It's actually, as they monitor usage, it's reducing the usage of PTO in most cases. So it's almost like employees feel guilty if they're taking too much PTO, comparing themselves to others. Even though they know it's unlimited, they're reluctant to do so. So it's something that puts you in a position to comply with the multiple laws requiring paid leave, but doesn't necessarily result in more time being taken off. Other developments we're seeing in this arena, the ADA, FMLA arena, are cases involving service versus support animals, pre-employment testing, and finally, cases on different types of accommodation under the ADA. As you can see, each case is different. There have been a lot of new developments in recent years, and you really have to stay on your toes as employers in order to comply with the FMLA and ADA. I hope that the examples that we've given this afternoon have been helpful to you, instructive. And with that, I'll conclude and tell you I'll be happy to answer any questions.
Thank you, Don. We do have a couple questions. Also, I wanted you to explain constructive discharge. Not everybody's familiar with that term.
Okay.
We'll start.
If an employer puts in an employee in a position that would cause a reasonable person to quit, then that is treated the same under the law as a termination. So sometimes we see it in harassment cases where the environment is so hostile that the employee quits, and they'll claim that they were constructively discharged, that the conditions in the workplace were so onerous that a reasonable person would quit. And that is deemed to be the same as a termination, and it's actionable, even though the person resigns. Does that explain it?
It sure does. Thank you. Also, let's see. So these are a couple of examples. I'll read the first one. An employee has high-risk pregnancy, used up all her FMLA prior to delivery. The doctor now asks to extend the leave for an additional month. Would this fall under the ADA? Yes, it would. But I'm going to let you expand on that. Would it be
well, you're correct. Yes, it would, because if it's a high-risk pregnancy, it's likely that there are related, it's not just pregnancy that's the issue, there are related medical conditions that are preventing the employee from being able to perform the functions of her job, and that would constitute a disability. So if it's a disability, you have to consider reasonable accommodation. Reasonable accommodation may include that additional month of leave. So depending upon what the job is, you have to evaluate whether it would create an undue hardship to have the person out for one more month. And if it would, you could deny it. In many cases, however, it will not create an undue hardship, and you would have to permit the additional 1 month of leave. One thing I should note in addition is that you have a unique concern there. It's not just ADA or FMLA. Because the individual's pregnant, there is the possibility of a pregnancy discrimination claim as well under Title VII, as amended by the Pregnancy Discrimination and Employment Act. If you were to terminate the individual, she could claim that you had permitted others to take additional leave and you did not allow her to because hers was related to pregnancy. that in and of itself would be a violation of the law. So not only do you have a potential ADA issue where you need to accommodate, but you've got a potential pregnancy discrimination issue as well.
Okay, thank you. 2 more questions, actually. The first, we have an hourly employee returning from FMLA. As long as we continue to match her pre-FMLA total weekly hours and pay rate, are we at liberty to alter her post-FMLA work schedule based on adjusted business needs?
I would caution against changing her post-FMLA schedule or her work schedule. That could be deemed to be retaliation. Now, if you can demonstrate that the schedules of others who were not on FMLA have been altered during that period of time as well, and she was in a position like others who had their schedule altered, then you could do it. But if you do it just with that employee, I would be concerned that that could result in a retaliation claim.
Okay, great, thank you. The other question was actually a little earlier, and I believe it's regarding the exam for FMLA that an employer may ask for a second exam. And the question is, who pays for the exam, employer or employee?
Under the FMLA?
I think that's what it is. If you're still on, Linda, if you want to retype that or otherwise send, a message, that would be great.
Well, generally the second exam is the employer's responsibility, where you're questioning what the employee has provided under the FMLA. Then
that's what I think.
Yes, if that's what we're talking about, then that's the employer's responsibility.
Okay, and that is all of the questions I see. So I am going to go through a couple of slides. If you do have a question you think of during that time, please go ahead and use the chat feature. But Don, I want to thank you for being our presenter today. As always, it's highly informational and great information, though we might not like it. It helps us with that, figuring out what to do, or at least understanding what's happened in other cases. So thank you very much.
My pleasure. Thank you.
You're welcome. I do also want to remind our attendees, if you do have a SHRM or an HRCI certification and you do want the credits, just request those by either calling us on the number on the screen or emailing our HR Service Center, which is also on the screen. If you are not seeing that, the number is 888-335-9545, and the email address is hrsc@alphastaff.com.